website, we have some materials for you that are very helpful in dealing with whistleblower claims. Again, since it's a relatively new law, a lot of railroad workers that I talk to are not even aware that they have this protection. On our website, there's a flow chart that we've provided, and it goes through after you've experienced retaliation from the railroad, and again, it has many phases what you need to do. So again, for whistleblower, the protected activity all deals with safety. So the examples that are given under the statute that are protected are one of the main ones. If you've had a personal injury, they can't retaliate against you for having a personal injury and reporting it. If you have a coworker that's had a personal injury and you are one of the witnesses to that and you're helping in an investigation or with their claim, they can't retaliate against you for being a witness for a personal injury case for another coworker. Anything that deals with safety. So if you are, working with equipment and it's broke and the railroad's telling you, well, just, deal with it, find something else. Anything that you report that deals with safety is also protected activity. So it's called under the statute. And if you are following the orders of your physician by either staying out of work because you can't work and they're keeping you, you're doing physical therapy, whatever kind of treatment, that's protected if the railroad says to you, I'm sorry, you need to get your butt back because, we're not, you need to be back at work. We're going to charge you with absenteeism. That's protected. Again, on the flip side of that, if you are ready to come back to work and you have to take the return to work physical and be able to mark up and the railroad is blocking that, that's a whistleblower violation because you're trying to follow the orders of your physician, which is to be able to return to work. So those are all your protected activities. That's, again, OSHA, it's the umbrella is safety. They want to make sure that anything that you're doing to protect yourself and to be safe on the railroad, that's something that they help with, that they cover you for. So the retaliation part of it is a little bit more complicated because railroad workers ask me often, well, Carissa, what does that mean by retaliation? And it has several different phases. So retaliation can be discipline that you're receiving out of the blue for something you've done 1,000 times, and all of a sudden, railroad says that you are doing it incorrectly or you're getting disciplined for it. If they're charging you with rule violations over and over again for things that, again, you've done, or your coworkers are doing the same thing and they're not getting charged with a rule violation under the law, that's called disparate treatment. They're treating you differently. And so that is a type of retaliation. If they're trying to force you, again, to come back to work when you've been hurt or keeping you out. All of those disciplines, if they're demoting you, if they're not paying you equal to your coworkers, all of those things are considered retaliation under the statute. And those are all adverse actions. And so when one of those things happens, I tell workers the most important thing to do is to document it. You need to report it to your union. You need to report it to the HR department so that most carriers have a hotline that you can call that's an ethics hotline. Call that. Make sure you report it on that hotline because those calls are typically recorded. Again, report it to your local chairman, your union, so they can document it. And then document it yourself. On our website, there's a way that you can get a free journal that just is a little book that you can keep notes in. Make sure you write down all the details of what had happened on the day that you had the adverse action so that you keep all that fresh in your mind. So when the railroad turns around and says none of this happened, you have documentation of it. And then again, always, if you ever had any doubts about whether it's covered under the whistleblower, whether it's a form of retaliation, please feel free to call us at Poulsen Oden. We can answer all those questions for you and let you know whether it's something that's covered under the whistleblower and what you need to do to protect your rights within that very short period of time you have to file a complaint, which is 180 days.